Mr. Torres, if you have something on your screen asking you to join a breakout session, please click yes or accept or join or whatever it's asking you to do.
Sure.
Mr. Torres never came into the breakout room, Judge.
He's okay. So Mr. Torres, Mr. Paniago, I'm going to put you in a breakout session with your attorneys. You're going to see something to pop up on your screen that asks you to join a breakout session. You need to go ahead and click join or accept or whatever it's asking you to do.
Yes, Your Honor.
Flattered everywhere. You're like, Jesus. Oh. Jeez.
All right, I have someone logged in as Melissa's iPhone. I need you to unmute your device and tell me your name, please.
Melissa Drilliard Eichenberg.
All right, 1 second. Sir Malero, do you need a breakout session with Ms. Juilliard Eichenberg?
If I could, Your Honor, yes.
All right, 1 second. Okay, Ms. Arnold, Mr. Chair, are you ready to proceed?
Yes,
Sure.
Or check that away again.
Judge.
Not till later today.
Yes.
Is the case called now?
Yes, so this is file 25-22261-FH. People of the State of Michigan versus Holly Eileen Schmidt. We are here today for a trial conference in this case, and we are proceeding today in person. First, can I ask the attorneys to place their appearances on the record, beginning with Ms. Arnold for the people?
Allison Arnold for the people.
And John Shea, Your Honor, with and on behalf of Ms. Schmidt.
All right, and Mr. Shea, where do we stand with Ms. Schmidt's case today?
Your Honor, thank you for the bench conference. As an initial, this is the first pretrial. In the first instance, I raised at the bench the issue of this court recusing itself from this case for reasons that are not exactly the same, but similar to those that underlay the court's sua sponte recusal of the family law case some years ago. The court, before taking the bench, had a professional relationship with a company in Tecumseh, which Mr. Schmidt, Holly's husband, was involved in. Your Honor's professional relationship involved Mr. Schmidt. Mr. Schmidt is a res gestae witness in this case. He was driving behind Ms. Schmidt at the time the accident occurred. Whether he would be called or not at trial, I guess, is a question that only the prosecutor knows at this point, and whether we would object, again, is something that we would have to take up at the time. But he is a res gestae witness. Mr. Schmidt's former partner, Kyle DeWitt, is Ms. Schmidt's former husband. The breakup of the dissolution of Ms. Schmidt's marriage to her former husband has been quite public, and there's been a lot of bad blood. There's been press, local press about that. It has also infected, I would say, the business and the viability of the business, if Your Honor advised. Given all of the personal intersections of this case, Your Honor's prior professional relationship with one of the actors who's a witness in this case, perhaps by extension, your familiarity with Ms. Schmidt as well. Seems to me that under the appearance of impropriety standard, certainly no limiting evidence of actual bias, but under the appearance of impropriety standard, we request the court to consider recusal.
All right, Ms. Arnold, do the people have any position on that?
We do not.
All right. I think that Mr. Shea has outlined my contacts with the people involved in this case in addition to doing some professional work for Mr. Schmidt and Mr. Lewis's company at the time. I was also a small investor in the original investments that occurred there, so I have that relationship as well. I do think that that presents a basis upon which I should disqualify myself for the appearance of impropriety, and so I will enter an order of disqualification, send this to go next to Judge Ansel. I can schedule a pretrial now. I do have some dates for her. I can do, I'm sorry, July 23rd at 8:15 for next available date.
That would be fine, Your Honor.
That's fine.
Set the same time, Your Honor.
Correct. Is there anything else we need to address with the case today then?
No, Your Honor. Thank you.
No, thank you.
All right, thank you for your time. Okay, Mr. Glazier, are you ready to proceed with Mr. Torres? You are muted, Mr. Glazier.
Yes, I am, Your Honor.
Okay, this is file 25-22298-FH and 25-22299-FH. People versus Randy Torres. We are proceeding today by video conference. We are here for an arraignment. First, going to have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Good morning, Your Honor. Isaac Sneed on behalf of the people.
John Glazier on behalf of Mr. Torres.
And Mr. Glazier, does Mr. Torres wish to have either of the informations read?
We waive the reading of those, ask the court to enter a plea of not guilty and set this matter for a pretrial in probably just a couple of weeks, not very far away.
Okay. Court will enter a not guilty plea for Mr. Torres in both files and set this for a pretrial conference I can do June 23rd at June 23rd at 8:15 a.m. July. Getting the
July
right month.
23rd.
Yeah.
All right, that'll work, Your Honor.
So July 23rd at 8:15.
All right, I got that.
Okay. All right, Mr. Torres, you can let the officer with you know that you're done with court for today.
Yes, sir.
Mr. Malero, are you ready to proceed with Ms. Julia Eichenberg?
I am, Your Honor. I am ready to
Okay.
proceed.
All right, 1 second. This is file 25-22141-FH, People versus Melissa Aline Juilliard Eichenberg. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, attorneys place their appearance on the record, beginning with Mr. Bannon.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Melissa Juilliard.
And Mr. Malero, where do we stand with the case today?
Your Honor, I would ask to adjourn this out. I'm working on a plan to get this matter resolved. I would ask the court for 60 days. I think we would be in a position to either have this resolved completely or set it for trial.
Mr. Banetto, anything you need to address from the people's side?
No, Your Honor.
Okay, what we'll do is adjourn this to September 3rd. At 8:15 a.m. Mr. Malero, would you do that stipulation in order for adjournment?
Yes, Your Honor, I would do that.
Okay, we're going to be approximately 200 days since the bind over at that time. So if it's not resolved, then I will set it for trial.
Understood. Thank you, Your Honor.
Okay, so Ms. Juilliard, your next date again is September 3rd at 8:15. You can log in using all the same Zoom information you used today.
Thank you, Your Honor.
Okay, Mr. Malero, Mr. Santiago is here in person. Are you going to need to speak to him?
Yes.
Okay, Mr. Santiago, if you would step outside to the hallway, there's an iPad out there, and I will put you in a breakout session with Mr. Malero. Mr. Dagger-Margosian, were you able to speak to Mr. Paniagua?
Yes, Your Honor.
Okay, and are you ready to go on the record?
Yes, Your Honor.
Okay. This is file 25-22163-FH, People of the State of Michigan versus Juan Carlos Paniagua. We are here today for a pretrial conference in case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Allison Arnold for the people.
Your Honor, Michael Dagger-Margosian for Mr. Paniagua.
All right, and Mr. Dagger-Margosian, where do we stand with the case today?
Your Honor, today is the time and date set for a pretrial. We do have a resolution with the people. Mr. Paniagua is going to be pleading guilty to count 3 DV, and that will be under 769.4A. Further, there is an agreement for no upfront jail. The remaining charges will be dismissed, and there will be a no contact provision with the victim here.
All right,
It's almost correct. What Mr. Dagger-Margosian left out is probation includes all appropriate terms, including no contact with the victim and completion of any assessment and counseling ordered by the probation department, and restitution as determined by the court for all counts, whether pleaded to or dismissed, will be paid by the defendant. I'm not aware of any restitution, but there may be some.
All right, is that all accurate, Mr. Dagger?
Yeah, that would all be part of probation, normal probation, Judge.
All right. Do we have a signed advice of rights form?
Your Honor, I can get that to the court. I spoke with Mr. Paniagua today. He told me he wants to accept that, so I can get it to the court today, this afternoon.
All right, Mr. Paniagua, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Juan Carlos Paniagua?
Yes, Your Honor.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 domestic violence?
Yes, Your Honor.
Are you satisfied with Mr. Dagger and the advice that he's given?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct?
Yes, Your Honor.
Correct, Your Honor.
Yes, Your Honor. It is correct.
Thank you. Mr. Dagger-Margosi?
Yes, correct, Your Honor.
Is that also your understanding, Mr. Paniagua?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Paniagua, that if your plea is accepted today, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 25, 2024 through September 24, 2024 in the city of Adrian, County of Lenawee, state of Michigan, you did commit the offense of domestic violence?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises or not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Paniagua to plead guilty?
No, thank you, Your Honor.
Mr. Dagger-Margosi?
No, no promises, Your Honor. Thanks. Other than what was put on record.
Mr. Paniagua, other than as we've discussed it on the record, has your attorney promised you any particular sentence or estimated what it would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentence agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Dagger-Margosi, do you want to cover the factual basis?
Mr. Paniagua, on the dates listed by the court, were you in the state of Michigan, County of Lenawee, City of Adrian?
Yes.
And on that date, did you have an encounter with Felicia Arnett?
Yes, sir.
And had you, prior to that date, had a dating relationship with her?
Yes, sir.
On that date, was there unconsented to contact with her? Did you grab her?
Yes, sir.
And she didn't agree to that grabbing?
No, sir.
Okay, I'm satisfied.
Ms. Arnold, are the people satisfied with the factual basis?
We are, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Mr.
Yes, ma'am.
Dagger-Margosi?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Paniagua's had full knowledge of his rights. He's had counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we discussed on the record here today. I will refer this matter to the district court probation office for a pre-sentence investigation and set sentencing for August 7th at 8:15 a.m.
Thanks, Judge.
Mr. Paniagua, someone from the district court probation office is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. You will need to report to the district court probation office this coming Tuesday at 8 a.m. So that's Tuesday, July 8th at 8 a.m.
Thank you, Your Honor.
Anything else we need to address in this matter today, Ms. Arnold or Mr. Dagger-Margosi?
No, thank you, Judge.
No, thank you, Your Honor.
Okay, so Mr. Paniagua, we can go ahead and log out. And again, you need to report to district court probation on Tuesday at 8 a.m.
Yes, Your Honor. Thank you.
All right, Ms. Underwood, I presume that was Mr. Evans. Were you able to speak to him?
Yes, I was, Your Honor. Thank you.
Okay. And let's see, Mr. Malero, do you need to speak to Mr. Levins?
Yes.
Okay, and Mr. Glazier, I don't have either Mr. White Eagle or Mr. Russell logged in right now. I don't know if you want to try to. Mr. Russell's here in person. Mr. Glazier, Mr. Russell's here in person. You need to speak to him. Mr. Blevins, I'm going to put you in a breakout session with Mr. Malero if you give me one moment.
All right.
No, Your Honor, I don't need to speak with Mr. Russell. I'm going to ask to set this over for another pretrial and have him come in and see me.
Okay, let me call the Evans case first, and then we'll get to Mr. Russell next. This is file 25-22174-FH People versus Jason Allen Lee Evans. We are here today for a pretrial conference. In this case, we're proceeding by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Rhonda Underwood for Mr. Evans.
And where do we stand with Mr. Evans' case today, Ms. Underwood?
Your Honor, the offer from the prosecution is Mr. Evans would plead to 1 count of assault on a prison employee. The habitual offenders would be dismissed in this matter. I've spoken with Mr. Evans a couple of times, Your Honor, regarding this, and Mr. Evans wishes to accept that offer today.
Okay. Mr. Sneed, is that an accurate statement of the plea agreement?
Yes, it is, Your Honor.
Mr. Evans, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Jason Allen Lee Evans?
Yes, sir.
Mr. Evans, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1 assault of a prison employee?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $2,500 fine?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Underwood?
Yes, Your Honor.
Is that also your understanding, Mr. Evans?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt you're guilty, and you do not have to prove anything. You have the right to be present at your trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Evans, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
Sir.
I'm sorry, I wasn't able to hear you.
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about January 5, 2025 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept a plea, you'll be giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Evans to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Evans, has your attorney promised you any particular sentence or estimated what your sentence would be?
Repeat that.
Has your attorney promised you any particular sentence or estimated what your sentence would be?
Yeah.
All right. Do you
Wait,
understand that?
No.
Okay. Do you understand, regardless of whether or not you've had any conversations about a sentence with Ms. Underwood, that it's the court's responsibility to set the sentence?
Yes.
and that any conversations you might have had with her are not controlling on what the court might do. The court can sentence up to the maximum amount.
Yes, sir.
Okay, if your plea is accepted and you engage in misconduct, the court would not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding, failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Sir.
All right, Ms. Underwood, do you want to cover the factual basis?
Thank you, Your Honor. Mr. Evans, I
Yes,
take you
ma'am.
back to January 25th, 2025. At that time, were you a prisoner in the Gus Harrison facility?
Yes, ma'am.
And you were lawfully imprisoned in Gus Harrison, serving a felony sentence, correct?
Yes, ma'am.
And Gus Harrison is located in Madison Township, County of Lenawee, State of Michigan.
Yes,
Is that
ma'am.
correct?
Yes, ma'am.
Thank you. At that date and time, did you come into contact with corrections officer Tennywood? And did you throw something assault him by throwing something at him?
Yes, ma'am.
And you had no permission to do that, correct?
No.
And he was within his lawful employment, correct?
Yes.
I think the factual basis is established, Your Honor.
Mr. Mr. Sneed, are the people satisfied with the factual basis?
Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Ms. Underwood?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Evans has had full knowledge of his rights and he's had counsel. Of course, not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the probation department. And for a pre-sentence investigation, and set sentencing for August 7th at 8:15 a.m.
Thank you, Your Honor.
That sentencing will be in person because we need fingerprints. So Mr. Sneed, I'll need the prosecutor's office to do an in-person writ, please.
Understood, thank you.
Mr. Evans, someone from the probation department will be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about this offense and about your background.
Yes, sir. And you said when is court?
I'm sorry, I couldn't understand what you said.
Court date? What's the
court
next court date?
The court date is August 7th.
Yes, sir.
Okay, so you're all set. You can let the officer with you know that you're done with court for today. You all set? Okay, Mr. Russell, do you want to come forward, please?
Oh, different guy.
So they check our toilet?
He's gonna go back there and I'll get it now.
Okay, this is file 25-22184-FH, People of the State of Michigan versus El Shabazz Donnell Russell. We are here today for a pretrial conference in this case, and we're proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
John Glazier on behalf of Mr. Russell.
And sir, you are El Shabazz Russell?
Yes, sir.
Mr. Russell is here in person. Mr. Glazier, where do we stand with this case today?
Your Honor, we'd ask to adjourn this for a pretrial, not too far away, just for enough time, Mr. Russell come in and speak to me in my office.
We're not going up there and speak. I was in a great situation, just got to work. Apologize.
So what I'll do, I'm sorry, Mr. Sneed, is there anything we need to address from the people's side?
No, I don't believe so, Your Honor.
So what I'm going to do is I'll adjourn this to July 23rd at 8:15. And at that point, it's going to be about 130 days since bind over. So if we don't have progress at that point, I will be setting it for trial.
Thank you, Your Honor.
Thank you, Your Honor. Come in and
Okay.
see me, Mr. Russell, okay? Set up an
Yes, sir.
appointment.
Apologize. No excuse, I apologize. Yes, sir.
Right. Yeah, just set up an appointment, come in and see me.
Okay.
All right. So Mr. Russell, you are all set for today. And then your next date is July 23rd at
Yes, sir.
8:15. Mr. Glazier, would you do that stipulation in order for the adjournment?
Yes, Your Honor.
Okay. And Miss, are you Cassie Lynn Coley?
Yes, Your Honor.
All right, this is file 25-22120-FH, People versus Cassie Lynn Coley. We are here today for arraignment on 2 bench warrants, and we are proceeding today by video conference. Again, Miss, you are Cassie Lynn Coley, correct?
Yes, Your Honor.
Have they given you copies of your warrants at the jail?
No.
We will call over there and ask them to get you copies of those. In the meantime, I will tell you that the warrant dated May 21st, 2025 alleges that you violated your bond conditions by tampering with your GPS tether. And the other warrant alleges that you failed to appear at the pretrial in this matter on May 21, 2025. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the right to be represented by an attorney at this hearing today and at any other hearings we have regarding these matters. If you can't afford an attorney, you can tell me that. The court will appoint one for you at public expense. Do you understand that?
Yes, Your Honor.
Do you want to be represented by an attorney today?
Yes, Your Honor.
Do you have the ability to pay for your own attorney?
No, no, Your Honor.
All right, I will appoint the public defender's office, put you in a breakout room with Ms. Underwood if you'll give me just one moment. The camera and the microphone are shut off on the iPad. Go fix that. Okay, Mr.
Good to go. That's what it is.
Mr. Santiago, if you hold on just a moment, I have one case to do with Mr. Malero, and then I'll put you in that breakout session with him.
Okay.
Mr. Malero, are you ready to proceed with Mr. Blevins?
I am, Your Honor.
This is file 25-22175-FH, People of State of Michigan versus Nicholas Montgomery Blevins. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Van.
Alex Bayoneto for the people.
Salvatore Malero, covering for Matt Murphy on behalf of Nicholas Blevins.
Okay, and Mr. Malero, where do we stand with Mr. Blevins' case today?
Here, I'm going to ask to adjourn this out past August. The basis for the request is, according to Mr. Murphy's notes and just talking to Mr. Blevins, he is in a rehab facility. He expects to finish with that in end of August. And so that would be why we're requesting that adjournment for that time frame.
Mr. Bayoneto, anything to address on the people's side?
No, Your Honor. Thank you.
I will adjourn this then to September 3rd at 8:15 a.m. And again, that case would likely be quite old at that time, Mr. Malero. So if we don't have a resolution in September, I would be setting that for trial. If you could communicate that to Mr. Murphy.
I will, Your Honor. Thank you.
And Mr. Malero, would you do the stipulation in order for that adjournment?
Yes, Your Honor.
All right, so Mr. Blevins, your next date then will be September 3rd at 8:15 a.m. You can log in using all the same Zoom information that you used today.
All right.
You can go ahead and log out then.
All right. For sure.
Okay, Mr. Malero, I'm going to put you in a breakout session with Mr. Santiago.
Thank you, Judge.
Ms. Underwood, were you able to speak to Ms. Coley or?
I was.
Okay, her device has disappeared. We're gonna have to call the jail and have them log back. Okay.
If there's something we forgot, it's just
It's gone.
It's just
They need
gone.
to log in.
Okay. Logged.
Mr. Blazer, did you have any success contacting Mr. White Eagle?
I didn't know he was out of jail, Your Honor. Every time that I've talked to him, he was in jail the last two court things, I believe. I can try calling if you hold on a second. I'll try right now.
Your Honor, do we have Mr. Dotson scheduled for today?
Yes, we do. He is not logged in and he's not here that I'm aware of. Would you like to try to call him, Ms. Underwood, or you want me to call the case?
Your Honor, unfortunately, the number I have for Mr. Dotson does not work. But Mr. Dotson was just in district.
Okay, let me call the case if you're going to give an explanation. Dotson. This is file 25-22227-FH, People versus James Alfred Dotson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, we have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Rhonda Underwood for Mr. Dotson, Your Honor. As I started to say, Mr. Dotson was just in district court last week, Your Honor. It might have even been earlier this week. He shows up for court, Your Honor. I don't know if he got mixed up. I'm sure that once I get a hold of him, this can be resolved very quickly. I would ask perhaps if the court would schedule a show cause in maybe 2 weeks, if the court would consider doing that. Mr. Bayanetto is aware that he was in court, Your Honor.
Mr. Bayanetto, anything you would like to say on the issue?
Your Honor, Mr. Dotson was in court last Thursday on his misdemeanor case. However, looking at some of his older cases, it does look like he does have a history of failing to appear. I think a bench warrant would be appropriate in this case. I wouldn't object if the court were to issue that with a 48-hour hold, but this case has been pending for a few months at this point in circuit court. I think a bench warrant would be appropriate, and that's what I would request.
This is obviously a mix-up on Mr. Dotson's behalf. I don't think there's any intent not to appear in court.
All right, what I'm going to do is set this for July 23rd at 8:15 a.m.
Thank you, Your Honor.
I will treat this as a first failure to appear, and so if he does not appear on the 23rd, he will not be entitled to the 48-hour grace period, and it will not be given.
Understood, Your Honor. Thank you very much.
Okay, and then we have Ms. Coley back, so we can continue with file 25-22120 -FH. Ms. Underwood, you know how Ms. Coley wants to proceed with respect to the
We
two
would ask the
contempt
court
ones.
to enter a not guilty plea on Ms. Coley's behalf. This is Mr. Murphy's case. I believe it's Judge Angelone's as well. So we would ask you to schedule that for next Wednesday with Judge Angelone. If
This
I'm
is
correct.
not Judge Angelone's case. This is
Oh,
my case.
Then I apologize.
Will enter not guilty plea for Ms. Coley on both contempts. I'll set everything for a pretrial on my next 2 weeks are full, so July 23rd is the next opportunity. So July 23rd at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Ms. Coley, you can let the officer that's with you know that you're done with court for today.
Yes, thank you, Your Honor. Have a nice day.
Thank you. He just went to blow. He went to
Hello?
All right.
Okay. I'm gonna get called.
Coley lots.
We don't have to go back.
You don't have
No, that one should be. There's no discharge of probation.
Mr. Malero, I do have Mr. Cadell here. Do you need to speak to him?
Yes, Your Honor.
Thank you.
Okay, Mr. Cadell, if you're there, I need you to unmute your device. Mr. Cadell, if you can hear me, I need you to unmute your device.
Yes.
Okay, I'm going to put you in a breakout session with Mr. Malero. If you give me just a moment.
Mr. Who?
Mr. Malero.
That's not my attorney. Matt Murphy was.
Mr. Murphy's not available today, so Mr. Malero is covering his cases.
Okay. But Matt. Oh, John.
Okay, Mr. Glazer, did you have any success contacting Mr. Whitey?
I did not hear. I called the number I had for him and left a message, and I had my secretary check booking, and he was just released on the, let me see, what did he say, the 15th. Mr. White Eagle is an older gentleman. I would ask the court maybe to adjourn this a week and let me send him a letter.
Let me call the case so we can have a record of it. So
Okay.
this is file 25-22235-FH, People versus John F. Kennedy, White Eagle. We are here. I'm sorry. Also file 23-21423-FH. We are here for a probation violation in the 23 case and a pretrial hearing in the 25 case. First, can I have the attorney's place there, appearance on the record. Mr. Sneed, are you appearing on this one? Mr. Sneed, are you there? Mr. Sneed, are you there?
No.
Judge, Mr. White Eagle failed to report yesterday as well.
All right, let me. Pass this for a moment and we can go, no, we can't go to Mr. Santiago's case. Okay, is Ms. Wright here?
Yes.
This is file 25-22217-FH, People versus Erica Lynn Wright. We are here today for a hearing on a Ms. Wright's turning herself in on a bench warrant for failure to appear at a pretrial and a contempt hearing on May 21st, 2025. Ms. You are Erica Lynn Wright.
Right.
Have you received a copy of the warrant?
No.
I'll get you a copy of that. So the warrant alleged that you violated your bond conditions by failing to appear at a pretrial and contempt hearing on May 21st, 2025. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You have the right to be represented by an attorney here today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes.
You want to be represented by an attorney today?
Yes.
Do you have the ability to pay for your own attorney?
No, you're right.
All right, so I will appoint the public defender's office. If you will step outside of the hallway, there's an iPad on a stand out there, and I'll put you in a breakout session.
Thank you.
All right, Mr. Sneed, are you there? He just left.
He's coming in now, Your Honor. He had to step out for a second.
Yes, Your Honor.
All right, so again, these are files 23-21423-FH and 25-22235-FH, People versus John F. Kennedy White Eagle. Mr. White Eagle is not present here today, either by Zoom or by video conference. Mr. Sneed, do you want to place your appearance on the record?
Yes, good morning, Your Honor. Isaac Sneed for the people.
John Glazier on behalf of Mr. White Eagle.
And Mr. Glazier, as I indicated, Mr. White Eagle is not present today. Is there anything you want to say with respect to that issue?
Yes, Your Honor. Back on June 4th, we adjourned this matter to this date, largely for the reason that I was going to have him screened for drug court, and I don't believe he qualified or he got rejected on that. But he was in jail at that time, and evidently he bonded out, or I don't know if he bonded out or what, but he was released on June 18th. And so I haven't had any contact with him. I called and left a message, or excuse me, June 15th is when he was released from the jail. I left a message on his phone. He's an older gentleman. I would ask to maybe adjourn this the next week and let me send him a written letter advising him of the new date.
Yeah, John, he actually was given time on a time in jail on the previous contempt for testing positive and for
Okay.
not drug screening.
So
So
that
he
just
was
ran out.
released. I did put him back on colors. And then he was positive for cocaine on 6/23 and also 6/24. So this is his second contempt.
Yeah, he's got a contempt and a pretrial for today. The last I talked to him was on the 4th, and I don't, I assume he was given that date, but he's an old man. But if the court wants to issue a warrant, that's fine. But if not, I'd send him a letter and advise him to be here next week. And I did leave a message on his phone.
All right, the court did issue a warrant for Mr. White Eagle on June 27th for another positive test.
Okay.
On the 23rd and the 24th after he was released. And so I think it would be appropriate in this case to issue a warrant for Mr. White Eagle's failure to appear. He unfortunately seems to have gone back to actively using substances, and therefore I think a warrant is the appropriate course of action. So I'm going to issue a bench warrant for his arrest. I'm going to set bond on the bench warrant in the amount of $50,000.
All right, thank you. And if he calls my office, I'll inform the court right away. I left a message on his phone.
Okay.
All right, thank you, Your Honor.
Yeah, and I'm sorry, that is in both files. Okay.
That's all I have. I'll see you later, Your Honor.
Thank you, Mr. Glazier.
Thank you.
Ms. Wright, you can come forward again. All right, Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Ms. Wright this morning, Your Honor.
And do you know how she would like to proceed today?
Your Honor, this is Mr. Murphy's case. Ms. Wright did turn herself in, and she's also availed herself of rehabilitation for, I believe, 30 days, Your Honor. We would ask that the court enter a not guilty plea on Ms. Wright's behalf on these issues and set it with the first available pretrial for Mr. Murphy and issue a PR bond in this matter.
Judge, she did provide me proof that she was in short-term residential at Dawn Farms. She was there from 6/4 until 6/26.
So I'll enter a not guilty plea for Ms. Wright. I will set this for pretrial with Judge Angelo on July 23rd, and I will issue a PR bond.
I have open heart surgery on July 22nd. Your Honor. And I gave proof to Mr. Coast.
Perhaps Mr. Murphy will have to speak to the prosecutor, Your Honor, on scheduling in this matter.
And Judge, she did provide me proof. She does have a surgery procedure scheduled for July 22nd.
So we'll set it for August 6th, then would be the next available date for Judge Angelo.
Thank you, Your Honor.
Hey, Erica, when you're done there, I'm gonna need to see you out in the hallway.
Okay.
Good luck, Ms. Wright.
Thank you.
You're all set.
August 6th at
8:50.
Okay, thank you so much.
Okay, Mr. Malero, are you ready to proceed with Mr. Santiago?
Yes, Your Honor.
This is file 24-21935-FH, People of the State of Michigan versus Michael Ramon Santiago. We are here today for a pretrial conference, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr.
Isaac Sneed for the people.
Salvatore Malero on behalf of Michael Santiago.
Mr. Malero, where do we stand with Mr. Santiago's case today?
Your Honor, I reviewed the show cause with Mr. Santiago, and we would plead not guilty to that. He is scheduled for a sentencing on August 7th. We discussed some kind of issue about what occurred. I would just note that these are low numbers, and I would like to probably take some time to talk to Mr. Coast about what's alleged in the show cause. So I'd ask to adjourn this to the August 7th sentencing date to see if we can get all matters resolved.
All right, I will set this then for the sentencing date is August 7th at 8:15 a.m. So Mr. Santiago, August 7th at 8:15 a.m. will be the date. You're all set for today.
Okay. Good, yeah?
Yeah, you're good.
Okay.
Thank you, Your Honor.
Okay, Mr. Dagger Margosian, I believe Mr. Barnett is here. Are you going to need to speak to him?
I don't think so, Your Honor, unless Mr. Barnett needs to talk with me. I think we know how we're going to resolve this case.
Mr. Barnett, do you want to speak to your attorney? Is that not Mr. Barnett?
I don't know. Yeah.
Oh, you said he was here. Sir, what's your name?
John Wayne.
Oh, you're Mr. White. I apologize.
Surgeon, the guy who was leading out the French.
Yes. Yes. Mr. Glazier, do you want to speak to Mr. White Eagle?
Yes, I need to, Your Honor.
Mr. White Eagle, if you'll step outside to the hallway, there is an iPad out there, and I'll put you in a breakout session with Mr. Glazier. I need you to turn the iPad back on. It got shut off. Is file 25-22302-FH, People of the State of Michigan versus Kevin Lee Barnett. We are here today for an arraignment. In this case, we are proceeding today by video conference and in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Mr. Barnett.
And sir, you are Kevin Lee Barnett.
Yes, sir.
Mr. Dagger Margosian, does Mr. Barnett wish to have information read today?
No, Your Honor, thank you.
And do you know how Mr. Barnett wants to proceed?
Your Honor, for the arraignment, we'll plead not guilty, but we do have a resolution with the people. We'll be entering a plea today.
All right, and what are the terms of that plea agreement?
The court should have an amended information. Mr. Barnett will be pleading guilty to count 2 R&O and count 4 careless driving. In exchange, the original information and habituals would be dismissed. Further, there is a sentencing agreement for no upfront jail for sentencing.
Mr. Sneed, is that a complete and accurate statement of the plea agreement?
The one added term was that the victim's permitted to make an impact statement at sentencing if she chooses, which I understand is standard procedure, but that's what's noted in the plea form.
Okay. All right, is that accurate, Mr. Dagger-Margosi?
It is. I think the reason why that was put in is because the offense that would have qualified for the Crimes Victims' Rights Act is dismissed, so we don't have an objection to that added term.
Do you need to have Mr. Barnett sign an advice of rights forms, or do you want to take this to him, please?
Judge, Mr. White Eagle never it didn't show up on
Okay, I don't
the session.
know what happened. I think he logged it out somehow. It's gone again.
All right.
Give us a minute. We'll try to get that taken care of.
All right.
All right, I do have that signed advice of rights form now. Mr. Barnett, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty before perjury?
I do, Your Honor.
And you are Kevin Lee Barnett?
Yes.
Mr. Barnett, you've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to count 2 assaulting, resisting, obstructing a police officer.
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine.
Yes.
Is it also your intention to plead guilty today to count 4 on the omitted information, careless driving?
Yes.
You understand the maximum possible penalty for that is a $100 fine?
Yes, sir.
Are you satisfied with Mr. Dagger-Margosian and the advice that he's given?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Dagger. Is that also your understanding, Mr. Barnett?
It is.
If guilty plea is accepted, there'll be no trial. This means that you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Barnett, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights? And do you understand that you're giving those up? How do you wish to plead to the charge that on or about May 10, 2025, in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, or obstructing a police officer? And how do you wish to plead to the charge that on or about May 10, 2025, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of careless driving?
Yes, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, they have not.
You understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Barnett to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Barnett, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record today?
No, Your Honor, yes.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
It is.
Mr. Dagger Margosi, do you want to cover the factual basis?
Mr. Barnett, on May 10th of this year, were you in the city of Adrian, County of Lenawee, State of Michigan?
Yes, I was.
Were you operating a motor vehicle, a Ford Expedition, on that date?
I was.
And were you operating it in a careless or negligent manner, likely to endanger any person or property, but without wantonness or recklessness?
I did.
Okay. And on that same date, did you have an encounter with law enforcement officer Eichmann?
Yes, I did.
Did you oppose or disobey a lawful command by him to talk with him or stop operating the car?
I did.
And you knew him to be a police officer?
Yes.
Okay, I'm satisfied.
Mr. Sneed, are the people satisfied with factual basis?
Yes, thank you.
Has the court complied with MTR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Mr. Dagger Margosian?
Yes, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Barnett has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than that we've discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing. This is Judge Antelope's case. Sierra, are you there?
Yes, Judge.
I need a sentencing date for Judge Antelope, please.
6 weeks out?
Yes, please.
Thursday, August 7th?
I'm sorry, did you say August 7th?
Yes, sir.
Okay, so sentencing will be Thursday, August 7th at 8:15 a.m. Mr. Barnett, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background. And the probation department is just across the hall. You need to stop in over there before you leave the courthouse today and pick up, they'll have a packet of information for you. And Mr. Barnett, I apologize. So the plea was given before me today. This case was assigned to Judge Anslow, and she's been the one to handle it. But what the law says about that is that you have a right to be sentenced by me because the plea was taken before me. If you wanted to be sentenced by Judge Anslow, you have to waive that right in order to go back to her court. Do you want to do that?
No, unless I have to.
You don't have to do. It's your choice. It's what I'm trying to tell you. Who would you prefer to do the sentencing?
You can have that.
Okay. So then it will be, I think my August 7th is filled up, so we're going to have to change that date. So it'll have to be August 8th. So Friday instead of Thursday at 8:15. Okay, so when you do your interview, please be truthful about these offenses and about your background. It's also my understanding, Mr. Barnett, you have a no alcohol provision in your bond conditions. Right. So I'm going to ask you to step into the hall and see Mr. Post and do a PBT with him. You just step out to the hallway, wait, he'll come on and see you.
Okay.
Okay, Mr. Malero, are you ready to proceed with Mr. Cadell?
Yes, Judge.
All right, Mr. Cadell. So this is file 25-22284-FH. People of the State of Michigan versus Matthew Allen Cadell. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Matt Cadell, filling in for Matthew Murphy.
Sir, you are Matthew Allen Cadell?
Yes, sir.
All right, Mr. Malero, where do we stand with Mr. Cadell's case today?
Yeah, there is a plea agreement on this matter. Hopefully the court has received it by now.
I have.
Okay. That according to paragraph 2, Mr. Cadell will plead guilty to added count 2, use of cocaine. There's a sentence agreement of no upfront jail. The paragraph 4, the habitual offender notice in count 1 will be dismissed. There is no restitution, and all other terms marked in the plea agreement apply. I signed on behalf of Mr. Murphy per his direction yesterday, and Mr. Cadell gave me permission to sign his name today. I believe that is the plea agreement, Your Honor.
All right, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
All right, I don't have a signed advice of rights form from Mr. Cadell. Has that been signed, Mr. Malero?
That I do not know, Judge.
I can't take a plea without having that under the new revised court rule.
Let me look and see if there's something in the file. I do not see anything designated as advice of rights, Judge.
I think I saw one in district court downstairs. I think I remember signing one.
Yeah, I think they has to have one signed separately in circuit court, Mr. Cadell.
All right, so Mr. Cadell, if you're available to come into the courthouse, you can sign one here, or I'm gonna have to adjourn this to another date, and we need to get a signed form before that.
I could be there in like 10 minutes because I get dropped off.
We can pass this then for a couple moments, and if you want to come up to the third floor, courtroom 1, we can have you sign that and we'll get it finished.
Third floor, right?
Yes.
Correct.
All right. I'll be there in like 5-10 minutes.
All right, thank you, Judge.
I can log off.
Yeah, you can log off, Mr. Cadell.
All right, thank you.
Your Honor, is Mr. Dotson by any chance in your waiting room?
I don't know, Rhonda. I have my hands full right now, and I will get to who's in my waiting room as soon as I can. I have someone logged in on a device that is labeled Google Pixel 6a. I need you to unmute your device and tell me your name.
I just got it. Okay, I got it. Thank you.
What's your name, sir?
James Dotson.
Ms. Underwood, do you need to speak to Mr. Dotson?
Yes, please.
Mr. Malero, do you need to speak to Mr. Madison?
Yes, Judge, I think there might be a plea in this case.
Okay. All right, this is file 25-22302-FH, People versus Kevin Lee Barnett. We are back on the record. I had, when we concluded, asked that Mr. Barnett do a PBT with Mr. Coast. Mr. Coast, how did that turn out?
Judge, I actually met with him in circuit court probation. He does smell of intoxicants. We did do a breathalyzer and it registered a 0.047% BAC.
All right, Mr. Sneed, anything you'd like to say with respect to that issue?
Well, Your Honor, I only know that that's, half the legal limit to drive. I'm not an expert and I can't make a determination whether or not that amount of alcohol would allow someone to knowingly enter into a plea or not. So I would defer to the court's discretion regarding that issue.
Sir Dagger Margosian.
Your Honor, I with the specific question of if the court hearings today are valid, from my opinion, I don't see any unknowing, not knowing what is happening from Mr. Barnett. So I think the court proceedings were fine. As far as what the court wants to do regarding the positive test, I guess that's a different question.
Mr. Coach, is he currently on any testing conditions?
Judge, he is not. He's got the no alcohol clause, but he is currently not in any program to do random PBTs. Obviously, I'd like to set him up with that.
All right, so at this time, I'm going to modify bond conditions so that Mr. Barnett will need to do random PBT testing with Mr. Coast. Pending sentencing. I don't see any other bond condition violations in the file, so I think that that's an appropriate next step. So that's what I'm going to do with this at this point is modify the bond conditions. I would remind you, Mr. Barnett, that as I said, if you engage in misconduct, including violating the alcohol condition of your bond between now and the sentencing, any agreement you had with respect to what your sentence would be can be nullified. I don't have to follow it at that point. So you've got some things at risk here if you continue this kind of behavior. All right. Mr. Coach, do you need to see him again in the hallway to set?
I do, Judge. I do need to see him in the hallway. And what is the sentencing date again?
August 8th.
Very good. Thank you.
Okay. All right, so I think we're all set then. Mr. Barnett, if you'll just step back out to the hallway, you can see Mr. Coach to get your testing set up. Thank you.
Thank you.
Johnson. It's file 25-22227-FH People versus James Alfred Dotson. We are here today for we're having an audio issue right now with our recording system. We'll continue as soon as that is resolved.
Okay, can you hear me?
Yeah, we can hear you fine. We're having a problem with our recording system.
Oh, okay, thank you.
Okay, yeah, that has resolved itself. So People versus James Alfred Dotson, we're here for a pretrial hearing this morning, proceeding by video conference. Can I have the attorney place their appearance on the record, beginning with Mr.
Isaac Sneed for the people.
Rhonda Underwood for Mr. Dotson.
All right, we've previously been on the record in this case. Mr. Dotson was not present. I adjourned it to, I think, July 23rd. And Mr. Dotson has since logged into the Zoom session. So Ms. Underwood, where do we stand with Mr. Dotson's case?
Your Honor, we believe there is going to be a plea in this matter. I thought Mr. Dotson would be here in person today. He is not, so I would ask the court respectfully to keep that date. That will give Mr. Dotson an opportunity to come into my office and sign an advice of rights and the plea agreement, Your Honor. And then we should be ready to proceed on the 23rd.
All right, so we will stick with that July 23rd date, and presuming we have all the paperwork in order, we will enter a plea at that time.
Thank you, Your Honor, and thank you for your patience.
Thank you, Your Honor.
All right, Mr. Dotson, you can go ahead and log out.
Okay, thank you, Your Honor. Have a good day.
Mr. Malero, are you ready to proceed with Mr. White Eagle?
No, that's John's case, Your Honor.
Oh, I'm sorry. Got people mixed up. I need those files back.
No, I kind of look like John a little bit.
We're twins.
Okay, I need to get my hands on those files again, so let me do Mr. Madison's case first, and then we'll do Mr. White next. Okay, these are files 25-22300-FH, 25-22301-FH, 24-21996-FH, and 24-21997-FH. Holt versus Brandon Madison. We are here today for a pretrial conference in those cases. There are also pending contempt of courts in the 2024 cases. I'm sorry, so the 2024 cases are pretrials and the contempts. The 25 cases are arraignments. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero, covering for Matthew Murphy on behalf of Brandon Madison.
And Mr. Malero, does Mr. Madison wish to have the information read in either of the 25 cases?
Your Honor, we would waive those readings, and I believe there's a plea agreement, and I may have had that emailed over to you. And I think it resolves all the felonies.
Okay, did you say that is being sent over? I don't think I have that.
Yeah, Your Honor, I just reviewed it with Mr. Madison and got his permission to sign it, so.
Okay. Okay, Mr. Malero, while we're waiting for that to arrive, do you want to state the terms of the plea agreement?
Sure. The terms are as follows, I understand it. And this involves files 301 FH, 300 FH, 997 FH, 996 FH. That with respect to the 996 FH file, Mr. Madison will plead guilty to count 1 as charged. And as to the 301 FH file, he will plead guilty to count 1 as charged. Pursuant to paragraph 3, there is a sentence agreement of 24 months at the Michigan Department of Corrections. Further, pursuant to paragraph 4, all remaining counts and habitual offender notices will be nolli prosequid. There is no provision for restitution. I explained paragraph 10 to Mr. Madison, and he indicated he understood that and gave me permission to sign his name, further indicating that he was not under any duress or coercion in agreeing to this plea agreement. I believe that is the plea agreement in this matter, Your Honor.
Okay, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor. Thank you.
So we need a signed advice of rights form from Mr. Madison. We will contact the jail and have them take him a copy of that form. Okay, Mr. Madison, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Brandon Lorzen Joe Madison?
Yes, sir.
Mr. Madison, you've heard the statement of your attorney and prosecuting attorney. Is it your intention to plead guilty today and file 24-21996-FH to count 1, assaulting, resisting, obstructing a police officer?
Yes, sir.
Is it also your intention to plead guilty and file 25-22301-FH to count 1, possession of methamphetamine?
Yes, sir. Yes.
Do you understand that the maximum possible penalty for the assaulting, resisting, obstructing a police officer charge is up to 4 years in prison and/or a $5,000 fine?
Yes, sir.
Do you understand that the maximum possible penalty for possession of methamphetamine is up to 20 years in prison and/or a $30,000 fine?
Yes, sir.
Are you satisfied with Mr. Malero today, but Mr. Murphy otherwise, and the advice that they've given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct?
Yes, it is, Your Honor.
Mr. Malero?
Yes, Judge.
Is that also your understanding, Mr. Madison?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
Yes, sir.
You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Madison, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
You understand you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about March 25, 2025, in the city of Adrian, County of Lenawee, State of Michigan, you did commit the offense of possession of methamphetamine?
Guilty.
And how do you wish to plead in file 24-21996-FH to the charge that on or about August 14, 2024, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
You understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter the pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Madison to plead guilty today?
No, Your Honor.
No, Judge.
Mr. Madison, has your attorney promised you any particular sentence or estimated what it would be other than as we've discussed it on the record today?
No, sir.
If your plea is accepted and you engage in misconduct, court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear for sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Malero, do you want to cover the factual basis?
I can do the one, Judge. I don't see the information on the other case. The only thing I see is something about cocaine.
Okay, so which file are you going to do?
The 996FH file.
Okay, go ahead.
All right. So, Mr. Madison, is it true that on or about August 14th, 2024, in the city of Adrian, County of Lenawee, State of Michigan, that you did engage one officer, Michaela Snowberger?
Yes, sir.
And you, in some form or fashion, resisted, obstructed, or opposed Officer Michaela Snowberger?
Yes, sir.
And you knew that Michaela Snowberger was a peace officer in the City of Adrian Police Department?
Yes, sir.
And you do not dispute that Officer Snowberger was performing their duties as a police officer when
No,
you
sir.
Resisted and obstructed and opposed them?
No, sir.
And do you agree that by resisting, obstructing, and opposing Officer Snowberger, you caused some form of bodily injury requiring medical attention or medical care to her?
Yes, sir.
But specifically, do you know what injury was caused that required medical care?
I think she fell down and got a cut or something like that.
Okay.
I don't know. I've never,
All right.
I think that's what I heard.
Is the court in the state satisfied?
Mr. Snino, people satisfied with factual basis on that file?
I'd just like to make clear he's not contesting that the officer was injured. He said he didn't know. So I just want to make sure it's knowingly made.
You don't dispute that the officer was injured, Mr. Madison?
No, sir.
Thank you. I'm satisfied.
Okay, and Mr. Madison, on March 25th, 2025, were you driving a white Chevy Traverse in the city of Adrian?
Yes, sir.
And did you get pulled over at some point?
Yes, sir.
And after you got pulled over, did the officers search your car?
Yes, sir.
And did they find a blue pen containing white residue on it?
Yes, sir.
Did they also find a silver spoon containing brown or burnt residue?
Yes, sir.
And was that residue methamphetamine?
Yes, sir.
Did you have any legal right or reason to possess that methamphetamine?
No, sir.
And did you know that that was methamphetamine?
Yes, sir.
Mr. Sneed, do you believe that's an adequate factual basis?
I am satisfied, Your Honor. However, if I could just pose one question to Mr. Malero regarding the specifics of the plea. The count one in the current file contains a second controlled substance offense notice. My question is if Mr. Millero's understanding that that is part of the plea and that the habitual offender fourth notice is to be dismissed, or whether both the controlled substance notice and the habitual offender notice are to be dismissed.
You know, I can look at Mr. Murphy's notes. He did not, I'm just, going by the plea agreement. That's the 300, is that 300, right?
It's 301 FH ending.
Okay.
That's what turned the meth charge from a 10-year to a 20-year.
That's correct.
And are you saying you're keeping that on there? That's what I'm pleading to?
Yeah, Mr. Murphy did not state anything as to whether or not there was going to be a second offense notice, subsequent offense notice. Normally I would interpret that as they're all that as well as the habitual is being dismissed, but I cannot speak to whether it is or not.
Okay. At this point, I'm satisfied with the factual basis, Your Honor. If there's any issues regarding that, we can address it. So
to be clear, I pled to the second offense, right? Because that's what turned it to the 20.
Okay. If that was the intention, then let's place that on record, Sam.
Yeah. So Mr. Murphy did not make any comment to me about whether there was going to be a second offense notice.
So it's just a regular.
So my position, and I would think, as you've correctly alluded to, Mr. Sneed, is we'll probably address it later. But my position would be the second offense notice would not apply.
Okay.
But I don't know if that affects what the court wants to do. I think
that needs to be resolved before I accept his plea.
Yeah, like I want it done today. I want sentenced soon. Like that was the whole thing of taking this plea to get out of here.
I mean, if the court wants to give me a moment, I can reach out to Mr. Murphy and see what he thinks.
Okay.
And I could also just address the court on behalf of the people that we don't have it specifically noted. So I think he'll guideline to the 24-month sentence agreement, which we have in this case. So I think we're prepared to proceed with the factual basis the court has laid out for count one, possession of methamphetamine, and the people will be dismissing the controlled substance supplement and the habitual supplement.
Thank you.
Okay.
That's fine. Thank you.
All right.
Thank you.
So, Mr. Madison, then do you understand that with that dismissal of the second or subsequent offense notice that the maximum possible penalty would be up to 10 years in prison and or a $15,000 fine rather than what I described earlier?
Yes, sir. Yes, sir.
All right. And you still want to proceed to enter this plea, is that correct?
Yes, sir.
Okay. Has the court then complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, and thanks for the court's patience regarding that issue.
Yes, thank you, Judge. Yes, I believe the court has complied as well, Your Honor.
Hey, Mr. I was just going to ask Mr. Osler, before you like do the timing on my sentencing, can I get the quickest available sentence that I can get? I mean, I know there's a time that you guys have to go by, but can I not sit here no 50 days or 45 days as quick as you can get me in? Like I just did a PSI maybe a year and a half ago. Like it's too much, not too much has changed.
Okay, so I'm required to give the probation department 6 weeks to prepare a pre-sentence investigation report. And they have to prepare a new one every time there's a new offense. So
Okay.
I will abide by that, and I will get you the earliest sentencing date I can in compliance with those rules. I will accept Mr. Madison's plea that has been given understandably, voluntarily, and accurately. Mr. Madison has had full knowledge of his rights, he had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And set sentencing for August 8th at 8:15 a.m.
And oh sir, hey, I have those contempt of courts. I've been locked up since April to whatever it is now. Can we, so nothing comes back, can we get those out the way?
Yeah, we'll take care of those before you go today.
Okay, thank you.
So, Mr. Madison, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
Given the plea that has been entered today and the sentencing agreement, as well as the fact that Mr. Madison has already been in jail for considerable time on these charges and the contempts as well, I'm just going to dismiss any pending contempts in these cases to clear those out, and so we'll just be dealing with the sentence.
Thank you, Judge.
All right, I believe that covers everything we needed to address today. So, Mr. Madison, you can let the officer with you know that you're done with the court.
All right, thank you. Have a nice day.
Okay, let's see. Mr. Glazier, are you ready to proceed with Mr. White?
Yes, I am, Your Honor.
Mr. White Eagle, do you want to come forward, please? Okay, if you give us just a moment, our recording system is okay. This is file 23-21423-FH and 25-22235-FH. People versus John F. Kennedy White Eagle. We are here today for a pretrial conference in the 25 case and a probation violation in the 23 case. We are proceeding today partially in person, partially by Zoom. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
John Glazier on behalf of Mr. White Eagle.
All right, we had previously been on the record in this case. Mr. White Eagle was not here. He has since appeared here at So Mr. Glazier, where do we stand with Mr. White Eagle's case today?
Your Honor, I need to meet with Mr. White Eagle at my office. I expect we'll resolve this in a plea, but I need to meet with him. The last I talked to him was by Zoom back on June 4th. And at that time, we were trying to get him into drug court, but evidently he can't get into drug court. So I need to speak with him and probably the prosecutor try to resolve this. In regards to the contempt of court, he says he did not do drugs, he says there's some problem at the testing area that I don't know. He can explain what he had heard or what's going on, but he tested him today. He says he will not be positive. He's doing 30. What are you doing? 30 and 30, Mr. White Eagle?
Yeah, 90.
Who's that? Is that for district court?
Right
Who
here.
asked you to do 90 meetings in 90 days?
Who asked me?
Yeah, who told you to do that? The
Probation
judge?
officer. My probation officer has me do it.
Okay, your district court must be your district court. Okay. But he says he's doing fine. He's not doing drugs. If you want to test him today, you can. What I would suggest is do the contempt of court, and probably we can enter a plea at the next hearing, get this resolved. It could be within a week and a half.
Judge, he's got a long history of substance abuse. He's already been violated for testing positive for cocaine. He's tested positive for cocaine again twice. I just checked his log. In his last drug screen, he did miss, which was on June 29th.
All right, I'm going to set this for a pretrial on July 23rd at 8:15 a.m.
Oh, could I have a second here? Okay. All right. What was that? July 23rd?
July 23rd.
At 8:15?
At 8:15. With respect to the testing issue, I may have been inclined to have Mr. White Eagle tested again, but hearing that he has now missed a test since the 2 positive tests, I have serious concerns about compliance with the drug testing. And so, as I indicated, I did sign a warrant on the 27th based on the 2 positive tests on the 23rd and 24th. And have Mr. White Eagle taken into custody on that warrant.
Your Honor, those tests were not right. I was just gotten out of jail, and I came up here and I talked to my PO and I said, hey, this is Suboxone, cocaine. I've never even seen a Suboxone. And I came up here and I talked to them. I said, hey, this is not right. 3 times this cup. When I went to my AA classes, I've asked other people, and they've had those same things happen over there. I've been clean. I told her that. I said it wasn't fair to my sobriety. I'm still clean right today. I'm doing my 90/90. I've already registered for the outpatient. I'm telling you, Your Honor, that something is wrong with those cups or something.
And you've also apparently missed a test since then. So I've made my decision. I will have Mr. Coast test you today, and
I'm not the only one who's been complaining about.
I will have Mr. Coast test you today, and if you are in fact clean, I will take a look at this again.
Judge, he also has the option for those tests, I believe, if they was talking about the Lenawee Testing Center, to have them sent into a lab. It's up to him
Yeah,
to
I
pay.
don't have a job. I don't have money. I just got a job. They're charging me $20 for each one. I have to borrow that.
All right,
Well,
Mr. I'm sorry.
If you're gonna revisit it, will you let my office know or something?
We will, yeah, we will contact you, Mr. Wick. Mr. Cadell, you want to come forward? You want to hold the jail? Okay, we're back on the record in file 25-22284-FH, People versus Matthew Allen Cadell. Do now have a signed advice of rights form from Mr. Cadell, and Mr. Cadell is now here in person in the courtroom. So I believe we are ready to proceed at this time, and I apologize, Mr. Malero, had I had you state the terms of the plea agreement for the record yet?
I believe you did, Judge, but let me pull it up again. Somehow it got this taken off. I believe it's an amended information of use of cocaine and no immediate jail.
And Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Sir Cadell, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Matthew Allen Cadell, correct?
Yes, sir.
Mr. Cadell, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information use of cocaine?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine?
Yes, sir.
Are you satisfied with Mr. Malero and the advice that he's given?
Yes, sir.
If a guilty, I'm sorry, neither the prosecutor or the defendant or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Malero?
Yes, Judge.
Is that also your understanding, Mr. Cadell?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you give up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You can ask for a non-jury trial. And if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you're convicted at a trial. Sorry.
Yes.
And you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Any questions about any of those rights?
No, sir.
And do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about March 27, 2025, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of use of cocaine?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cadell plead guilty today?
No, Your Honor.
No, Judge.
Mr. Cadell, has your attorney promised you any particular sentence or estimated what your
Also,
sentence other than as we've discussed it here today?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Malero, do you want to cover the factual basis?
Yes, Judge. Mr. Cadell, is it true that on or about March 27th of 2025 in the city of Adrian, county of Lenawee, state of Michigan, that you were in fact using a controlled substance known as cocaine?
Yes, sir.
And you did not have any legal right or authority to use that controlled substance cocaine?
No, sir.
And you knew it was cocaine?
Yes, sir.
And you knew that you did not have any right to use the cocaine?
Yes, sir.
Is the court and the state satisfied?
people are satisfied. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Malero?
I believe the court has, yes.
I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Cadell has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. And we'll refer this matter to the probation department for actually the district court probation office for a pre-sentence investigation and set sentencing for August 8th at 8:15 a.m. So Mr. Cadell, you'll need to report to Mike McCarron in the district court probation office this coming Tuesday at 8 a.m.
Okay.
Tuesday, July 8th at 8. Okay. When you do your pre-sentence investigation interview, please be truthful about the offense and about your background.
Yes, sir.
Okay. So you are all set for today. Again, you just need to report to Mr. McCarron on July 8th at 8 a.m.
Okay, thank you.
Thank you. Okay, Miss, are you Maria Rodriguez? This is file 24-21897-FH, People versus Maria Rebecca Rodriguez. We are here today for arraignment on a probation violation warrant. And we are proceeding today by video conference. Again, Miss, you are Maria Rebecca Rodriguez, is that correct?
Yes, Your Honor, yeah.
Ms. Rodriguez, have you received a copy of the warrant?
No.
All right, we will we'll call the jail and have them bring you a copy of that. In the meantime, I will tell you that the warrant alleges that you violated your probation on or about July 1, 2025 by being involved in an assaultive, abusive, threatening, or intimidating behavior with your probation officer. You had previously in this case been convicted of possession of cocaine of less than 25 grams. And the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine.
Wow.
You do have the right to be represented by an attorney here today and at any other proceedings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yeah, I don't have one. I need one.
Do you want to be represented by an attorney?
Yes, please.
Do you have the ability to pay for your own attorney?
No.
All right, I will appoint the public defender's office to represent you, and I will put you in a breakout session with Ms. Underwood, if you'll give me just a Okay, let's see. Are we ready to proceed with Bobby White Eagle de la Garza?
Defense is ready, Your Honor. I don't know if Ms. Winooski is on. It's a special prosecutor, Judge.
I am. Only my name is Neil Brady.
Oh, hey Neil. Sorry.
I'm not.
I'm sorry, sir. What was your name?
My name is Neil Brady. I am on assignment, special prosecutor on behalf of the people.
Okay. And sir, you're Mr. de la Garza?
That is correct, Your Honor.
So this is file 25-22293-FH, People of the State of Michigan versus Bobby White Eagle de la Garza. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I ask the attorneys to place their appearances on the record, beginning with Mr. Brady?
Thank you, Your Honor. Neil Brady on behalf of the people, 42378.
Good morning, Your Honor. William Amadeo, P76194, on a special assignment with the Public Defender's Office for Mr. de la Garza. We both appear via Zoom, consent to such, and thank you for that. Bobby, please state your name for the court and the prosecutor know it is you in the car.
Bobby White Eagle de la Garza.
All right, and Mr. Amadeo, where do we stand with Mr. de la Garza's case today?
Your Honor, we do have a plea and sentencing agreement in place that I believe was sent over to your courts. I did send over to Ms. Wisniewski this morning. There's also going to be 2 brief oral motions on bond upon acceptance of the plea if you accept the plea and sentence agreement. I also will send over an advice of rights. I did review all that with him. Ms. Pfeiffer just emailed me. I thought that was in the file, so I apologize. But we are ready to plea today.
All right, go ahead and state your understanding of the plea agreement, and then I'll ask Mr. Brady to confirm.
Okay, the defendant will plead guilty to home invasion first degree. He will plead guilty to malicious destruction of property, 1,000 to 20,000. He will plead guilty to domestic violence. The habitual offender second will be dismissed, and the defendant will not be treated as a habitual offender. The defendant will also plead guilty to 2 misdemeanor assaults and batteries, and case 25-250417 will be dismissed. The defendant will pay restitution in all cases. There is a Killebrew agreement of no upfront jail. There is a agreement of 5 years probation v. People versus Killebrew. If he violates any term of probation, he can be sentenced up to 12 months of incarceration. His estimated guidelines are 36 to 60 months. On the home invasion one, the MDOP is 0 to 17 months. There's also a stipulation to enter into a PPO against the victim, Alyssa Carmichael. Bobby,
Yes.
do not talk right now, please.
Okay, sorry.
Yeah. And we have reviewed this in its entirety. I did ask Ms. Wisniewski if she was going to do the factual basis. Mr. Brady, if you are prepared for that, that's great. This was a last-minute plea. If not, I could whip something up, but I do think that's a complete terms of the resolution.
All right, Mr. Brady, is that a complete and accurate statement of the plea agreement?
That is my understanding. Yes, it is, Your Honor. I am not in a position to be able to describe a factual basis of this case, Your Honor, at this time.
All right, I will be able to do that, Judge, if you give me 1 minute. And I will get that done. And we are prepared to proceed with the plea, Judge.
Although I thought Mr. De La Garza was going to plead guilty, or at least that was what was described when you enunciated the plea. Is this going to be a no contest plea then?
This is going to be a guilty plea.
Okay.
And then there's going to be 2 motions for bond, which the people did not object to, and I'll make them afterwards if that's acceptable to everyone.
All right, Mr. De La Garza, would you raise your right hand, please?
Yes, Your Honor.
You swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes, I do.
And you are Bobby White Eagle De La Garza?
Yes, I am.
Mr. De La Garza, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1 first-degree home invasion?
Yes, it is.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $5,000 fine?
Yes.
Is it also your intention to plead guilty today to count 2 malicious destruction of property, $1,000 or more, but less than $20,000?
Yes, it is.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine, or 3 times the amount of the destruction or injury, whichever is greater?
Yes.
Is it also your intention to plead guilty today to count 3 domestic violence?
Correct.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine?
Yes.
Are you satisfied with Mr. Amadeo and the advice that he's given?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Brady?
That's correct, Your Honor.
Mr. Amadeo?
That is correct, Judge.
Is that also your understanding, Mr. De La Garza?
No, I was not aware of that. I didn't know that the prosecutor had changed.
No, Bobby, it's the same prosecutor office. Someone is just filling in, just so you understand. It's the same deal. It's just Ms. Wisniewski's not here. Mr. Brady is filling in today. It is her office. Do you understand?
Okay, yes.
Okay.
All right, so my question, Mr. De La Garza, was do you understand that no one has discussed a possible sentence with me other than as it's been discussed on the record here today?
Okay, yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at that trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. De La Garza, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, Your Honor.
Do you understand that you're giving those rights I've described to you up?
Yes, I do.
How do you wish to plead to the charge that on or about May 15, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of first-degree home invasion?
Guilty, Your Honor.
And how do you wish to plead to the charge on the same date and time in the same location that you did commit the offense of malicious destruction of property, $1,000 or more, but less than $20,000?
Guilty.
And how do you wish to plead to the charge that on the same date and same location you did commit the offense of domestic violence?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Correct.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. De La Garza to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. De La Garza, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've talked about it here today?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is.
Okay, Mr. Amadeo, do you want to cover the factual basis?
Yes, sir, I will. Bobby, we talked a little bit about this. To do a plea, do a factual basis. So I'm going to ask you some questions that you will just have to answer yes or no to. Do you understand that?
Yes.
Okay, and these, to get the plea, it's going to have to be yes, so we establish the elements of the alleged crimes. Do you understand that?
Yeah. Yeah.
Okay. I'm going to take you back to 5/15 of 25. Were you in the city of Adrian?
Yes.
Okay. And is Adrian in the county of Lenawee?
Yes.
And is Lenawee in the state of Michigan?
Yes.
And is that where all these offenses occurred?
Yes.
Okay. On that day, did you enter a dwelling at 635 South Madison Avenue, apartment C35 in Adrian, Michigan?
Yes.
Okay. Did you enter without permission?
Yes.
Okay. When you entered, did you scare somebody named Alyssa Carmichael? Was Alyssa
Yes.
Carmichael lawfully present when she was intimidated?
Yes.
Okay. In that same location, did you break a plate glass sliding door?
Yes.
Okay. The plate glass sliding door, did you have permission? You did not have permission to break that, correct?
Correct.
Okay. Was the sliding door valued $3,270 to the best of your knowledge?
To the best of my knowledge, yes.
And during this encounter, was Alyssa Carmichael terrified of what was going on?
Yes.
Okay. And did you mean to scare her during this process?
No.
Try that again.
Yes.
So let's be very clear for the court. did you mean to intimidate or scare Alyssa Carmichael during
Oh, I
this
didn't-
process?
You're kind of breaking up, but yeah, I didn't hear you the first time. Yes.
Okay, so you did intend to scare her during this process where she would feel like she was assaulted or a battery was coming, correct?
Yes.
All right, Judge, I think that covers the elements of all three clients, including venue if the people have no objection.
I'm satisfied as well. I'm satisfied, Your Honor.
Mr. De La Garza, if your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating your bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
And do you still want to proceed with your guilty plea?
That's correct.
Has the court complied with MCR 6.302 B, C, and D, Mr. Brady?
Yes, Your Honor.
Mr. Amadeo?
Yes, you have, Judge. Thank you.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. De La Garza has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. Other than as we've discussed it on the record here today, I will take the sentencing portion of the agreement under advisement pending the preparation of pre-sentence investigation report. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for August 28th at 8:15 a.m. Mr. De La Garza, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay, understood.
And Judge, there are two brief oral motions I'm going to make that I believe the people are stipulating to today.
Okay, go ahead.
One, I move that his tether be removed today. I did speak to the people, Ms. Wisniewski and Mr. Castleberry, who's prosecuting the misdemeanor cases in district court, had no objection to that. And I also asked that he be able to go out of state for the 4th of July holiday. He wanted to go with his family to Cedar Point. Obviously, I don't want him having a bond violation, but it was my understanding, and Mr. Brady, correct me if I'm wrong, that people were in agreement with that.
Yes, sir, I'm in agreement with that. Thank you, Mr. Amadeo.
And Judge, I could prepare an order if that's acceptable for the court, so you'd have the tether removed and the travel allowed. And I will also send over an advice of rights if the people have no objection to that. I'll take care of all that momentarily.
No objection.
All right, so based then on the agreement, I will make those modifications to the bond condition. And yeah, Mr. Amadeo, if you would send over orders, I will sign those.
Yes, sir. Thank you.
Okay, Mr. De La Garza, I'm going to put you in a breakout session with Ms. Walsh from the probation department. She's going to collect the information she needs from you and give you some directions on what you're going to need to do next.
Okay, thank you.
What was the sentence date, Judge?
August
Mr. Amadeo?
28th.
August 28th, 8:15.
August 28th?
Yes.
Okay,
Correct.
thank you.
Yep. All right. Thank you, Judge. I'll see you this afternoon. I'll get those orders over.
Thank you, Your Honor.
I'll be right back, Judge.
Okay.
And Bobby, go with Agent Walsh into the breakout room wherever she instructs you. Okay. I'll call you later and I will take care of those orders that we discussed. Have a good day.
Thank you.
Okay, we'll resume with Ms. Rodriguez's case as soon as Ms. Walsh is back. Ms. Underwood. Oh, okay, so Mr. Lindsay was dismissed by Mr. Karen. You called you. And Mr. Malero, we don't have Mr. Owen here in the courtroom or logged in. If you want to try to contact him.
Yeah, I'll reach out, Judge. I also have a Matthew May on my schedule, and I'm
Yeah,
pretty
we are
sure
just calling.
Oh,
We are
okay.
just calling the jail for him right now.
All right, thanks.
I believe Mr. Owen may also be at the jail, Your Honor.
Oh, okay. Can you ask him if Owen is there?
I'm sorry, what was that? I don't know that. Can you also tell me, do you have a Daniel Jason Owen? Okay, very good, thank you. Do you want him in a row too?
Yes.
If you can, could you get Mr. Owen in a room for the judge's file? Great, thank you. Bye.
All right, we are back on the record in file 24-21897-FH People versus Maria Rebecca Rodriguez. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Ms. Rodriguez this morning, Your Honor.
All right, and do you know how Ms. Rodriguez would like to proceed today?
At this time, Your Honor, we would ask the court to enter a not guilty plea on Ms. Rodriguez's behalf.
All right, I will enter a not guilty plea then for Ms. Rodriguez.
We would ask for a pretrial date as soon as possible, Your Honor.
Yeah, Ms. McGrane, what's the earliest pretrial date we could have for probation violation for Judge Anzalone?
Which what date do you typically set those of the week?
I don't know what her process is. I usually do them on Wednesday mornings.
I think that's something you guys do the same. So let me grab the book.
Wednesday morning won't work for me. I'm doing arraignments for Judge Olsaver this month.
Well,
How long of a hearing is that typically?
I don't think we're setting it for a hearing. You just wanted a pretrial. Is that right, Rhonda?
that's correct.
We could do if we can't do a Wednesday, we could do Tuesday, July 22nd at 8:15 or 8:30.
I'm gone all that week. Sorry.
Can we address bond?
Let's identify a date first.
I can do a Wednesday and like afternoon if that would work. Just sometime after arraignments, possibly.
Yeah, I'm looking. The judge is out, so this docket's pretty backed up. Give me just a second. We could do July 9th, next Wednesday at 1:30.
That's fine with me.
What time?
1:30.
Should be able to do that.
Okay, so that was July 9th at 1:30 PM. All right, so Ms. Underwood, what did you want to say about bond?
Your Honor, I would just point out this is a technical violation. It is highly unusual situation. I don't believe Ms. Rodriguez is a flight risk. I don't believe Ms. Rodriguez is a danger to anyone. I think whatever happened probably got heated on her behalf, and I haven't seen a report yet, but I suspect that Ms. Rodriguez will have no problem showing up for court, Your Honor.
All right, so the bond on the warrant actually just says $0. What, I had signed it in a hurry that because she had just been arrested, so Ms. Walsh, what?
I mean, typically that's what we do for violations, but for threatening behavior, we generally do that.
Okay.
That was. I don't believe she has anywhere she's living as well. I believe she's homeless.
No, I have a place to live. I have a home. I have a home in the 25 with my uncle. 1571 Dorothy Street, that's where I live at.
If she is released, Judge, I would request drug testing while she is on bond. She hasn't been doing that for us. She doesn't have a job, therefore she doesn't have money. But I would suspect that might be an issue right now with her.
Has she been tested today?
No, she was very combative this morning.
Oh, come on.
All right, what I'm going to do is leave it at no bond right now. I'm going to ask that Ms. Rodriguez be tested at the Lenawee County Jail today. If that test is negative, I would be willing to hear this tomorrow morning at 8:15 in terms of having some further discussion of the bond issue.
Thank you, Your Honor.
Ms. Rodriguez, you can let the officer with you know that you are done with court for today.
Okay, thank you. Have a good day.
Okay, are you Mr. May or Mr. Owen?
Yeah, Mr. May.
Okay, Mr. Malero, you need to speak to Mr. May. Mr. Malero, are you there?
There we go.
You're muted, Mr. Malero.
I'm right here. What?
Sorry, Judge, I wouldn't unmute. I don't know why.
Okay, do you need to speak to Mr. May?
Yeah, just for a minute, real quick.
Okay, we can call Alyssa Smith. Is file 20-20105-FH People versus Alyssa Marie Smith. We are here today for a hearing on an order to show cause with respect to an alleged probation violation. We are proceeding today by video conference. Courtroom is also open to the public. The record should reflect that this matter was set for hearing this morning at 8:15 a.m. It is now 11:25 a.m. Ms. Smith is not present here in the courtroom. She is not logged into the Zoom session, nor has she been at any point this morning. Based on that failure to appear, I am going to issue a bench warrant and set bond on that bench warrant in the amount of $50,000. And sir, you're Mr. Owen?
No, I'm Mr. May.
No, you're still, what? I apologize. I don't know what happened. Apparently I put Mr. Owen and Mr. Malero in a breakout session, so. Okay. All right, so Mr. Malero, I apologize. You were in a breakout session with Mr. Owen. Are you ready to proceed with him?
Yes, we're ready on Mr. Owen, Judge.
Okay. This is file 25-22208-FH. People versus Daniel Jason Owen. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Salvatore Malero covering for Matthew Murphy on behalf of Daniel Owen.
And Mr. Malero, do you know how Mr. Owen would like to proceed today?
Yes, Your Honor, I spoke to Mr. Murphy about this. He said to set the matter for trial.
Mr. Sneed, how long do you think is necessary for a trial in this case?
We probably would need 5 days.
Okay, Ms. Clark, or I'm sorry, Ms. McGrain, can you find us a 5-day jury trial date, please?
Did you said 5 days?
Correct.
We could schedule it as a backup. Or would you prefer a firm date?
You know, I think a backup may work at this point. Based on the evidence I reviewed, I thought a plea may be likely, and I'd like to confer with Mr. Murphy and continue negotiations. So I'm fine with the backup date at this point.
It would be backed up to Larry Clark and Milo Nelson. So it would start September 15th and continue through that week.
I'm also on those cases. I don't know if that could be that's soon, Your Honor. So if it were in fact to go, I would appreciate some more time. So if there's another date available, I'd appreciate that.
We could start September 29th. It would be, there is a civil bench trial scheduled that week, Judge. I'm not sure how you'd like to handle that.
I'm unavailable that week, Ms. McGrain.
Could do the week of October 20th. It would be a backup to Stephen Maples, though, which I'm not sure if it's likely to go.
That works. Thank you.
Yeah, that's fine.
So October 20th through the 24th. So let's do a final pretrial on October 15th. At 8:15, I will issue a scheduling order and I'll send you a copy of that.
Thank you, Your Honor.
Thank you, Judge.
All right, Mr. Owen, you can let the officer with you know that you're done with court for today.
Thank you, sir.
Thank you. And Mr. May, now I'll put you in a breakout session with Mr. Malero.
All right, thank you.
This is file 25-22194-FH and 25-22216-FH. People versus Matthew Ryan Ray. We are here today for pretrial hearings in both of those cases, and we are proceeding today by video conference. First, may I have the attorneys place their appearances on the record.
Isaac Sneed for the people.
Salvatore Malero on behalf of Matthew May.
And sir, you are Matthew Ryan May?
Yes, sir.
Okay, Mr. Malero, where do we stand with Mr. May's cases today?
Your Honor, we had Mr. May screened for recovery court, but we do not yet know if he's been accepted. So I would ask if the court could adjourn this for about 2 weeks, and we'll find out if he's been brought in.
Okay, I can do July 16th at 8:15 a.m. Mr. Malero, if you would be willing to do that stipulation in order.
Yes, I would, Your Honor.
Anything else we need to address with the case today?
No, Your Honor.
Mr. May, you can let the officer with you know that you're done with court.
All right, thank you, Your Honor. Have a great day.
Thank you. All right, I think we are done for the morning.
Thanks a lot, Josh.
Thank you, Your Honor.